Okay, good. I'm sorry. My internet died. In the middle of it. Apologies. Okay. Yeah, there we go. Okay. Can you guys see this at all, or that's the wrong chat now? Can you hear me? With this sweet Mario Rabbids? I think so. I think you can. FNAF is here. FNAF Master! How you doing? Hope you're having a good day. You deserve it. Thanks for coming. I appreciate it. Sorry about that. Internet, sometimes just straight dies, and that's what happened. Yeah. And that's what happened. Right in the middle of reading. Just suddenly everything went quiet. I was like, why isn't there music? Whoa there, cowboy. Alright, we're just over 50% through this, which is good. Probably actually like 75%. Don't have to do the last couple, so it's good. Alright, let's continue. Other kinds of damages. Aggravated damages. On termination, some distress is inevitable. Until recently, litigants need to show independently actionable wrong, such as intentional infliction of mental suffering before aggravated damages were awarded. That's according to the Prinzo case. The internet did an oof. The internet did an oof. The Game Awards, though? I know, it was awesome, wasn't it? There's so many cool things in there. So many games that look interesting, which I'm totally for. Totally for. I forgot to... I'll read that after. Delete Fortnite. Delete that. There we go. What is this? This is different. Oh, I thought it was the one that songs y'all put in. Sweet. Alright. What do you think of Joker and Smash? I'm happy that means Persona can come to Switch. Plus Persona music, plus Smash remixes, plus... I think it's awesome. I love seeing the third-party character. I didn't expect them, you know. I'm not expecting anybody. I'm trying to keep all my expectations low for it. But, I love it. I love it, man. We gotta finish Persona now. I think Persona 5 will come to Switch when Joker is released for Smash. Personally, I think so. The Avengers Endgame trailer looks lit. I saw that as well. I'm crazy excited. Seriously, the Joker thing, though, was amazing. I'm really happy to see that. Like, it made me so happy, man. You do a stream, like, one day after Christmas? Maybe. Probably. Possibly. Probably. Can you do a stream, like, one day after Weird Ending? Thanks for the Twitter follow. Yeah, no worries, dude. I called Joker in Discord and Nap doubted it. Really? Well, good on you, dude. I wouldn't have suspected him, to be honest. I really wouldn't have. I figured they like Sony too much that they wouldn't let Persona 5 come near Switch. Alright, punitive damages. Awarded to punish the employer, not to compensate an employee for non-monetary losses. Awarded when the employer acts in particularly reprehensible and malicious way. So nominal damages is more for the monetary losses. Punitive is when if Professor Shy Guy broke his arm, I duct taped it. Turns out to make it worse. I didn't report it to anybody. If he went to sue me, and the government also came after me, I would have punitive damages on my hand because I did everything wrong. So, not only is Shy Guy getting $500,000 from me, he's also getting an additional like $300,000, and I'm going to jail for 6 months. I was watching Alpharad and he mentioned Joker and Smash, and I clicked on like Persona fanboy mode activated. I feel that Joker's gonna be like Bale all over again. I'm okay with it. FBI open up. Don't you love when you're loading a game and then halfway through it was loading and it just flat out dies? I hate that. I'm sorry, dude. I'm sorry. Resident Car, I did not say hello to you, did I? I hope you're having a great day. You deserve it. Thanks for coming. I appreciate it. I don't think I give you an intro. Alright. There we go. But we gotta finish Persona 5 now. Or up to where we can without getting copyright struck. Wallace type damages. Extended notice period. Supreme Court of Canada case, Wallace versus United Grain Growers, court decided employer has a duty of good faith and a manner of dismissal. The breach of this duty can result in an extended notice period, as it is foreseeable that the employee may need more time to find alternate work, regardless of whether the employee actually affected the employee's ability, of whether the conduct actually affected the employee's ability to find a new position. Everyone's saying Joker's gonna be top tier. I'm okay with that. I'm okay with that too. I can't wait to play as him. I have a feeling I'm gonna love him. I really do, because I was surprised at how much I loved Corin. Like, I didn't even know who he was, and although I don't have a lot of experience with Joker, I have a feeling I'm gonna love him because I don't know. He seems awesome. He seems awesome. I understand how you can do this finally. For what? Joker will either be top tier cancer or gimmicky trash. One of the two, yes. One of the two. Absolutely. Either way, I'm gonna try him. I can't wait. Instead, an employee could establish a link. Oh wait, Wallace damages. These are important. The Wallace decision made it easier for wrongfully dismissed employees to Okay, I understand. Okay. The Wallace decision made it easier for wrongfully dismissed employees to obtain higher damage awards. It was no longer necessary to establish that the employer committed an independent tort, like intentional infliction of mental suffering. Just all the time. I hope that's okay. I don't feel like I've been nice to you guys here. I feel like I've been a real jerk to you guys this year. I'm really sorry. I feel like I've had such an attitude about everything, so I apologize for that. Blue, that's only the first place you're in. Copyright makes you only able to go up to the last palace without copyright. That's true. Yeah, you're right. Just means you guys wouldn't see the end of the game, which I don't know how I feel about. I'm not watching any Smash Ultimate videos because I don't want spoilers until I get the game. I'm only gonna watch Dashy if he uploads some, but no World of Light stuff. No World of Light stuff at all. That's it. I don't mind watching people fight though. Instead, it feels no longer necessary to establish that the employer committed an independent tort, like intentional infliction of mental suffering. Instead of an employee but now I'm debating waiting until the Smash. And you know there's going to be a Switch version of Persona 5. I think there's going to be one, right? Final Fantasy VII's coming to Switch. Fantastic. We got Cloud from Final Fantasy VII, which is sick. I'm considering waiting because they're definitely going to have other stuff in it. They're going to have like different costumes. They might have different quests in it. Man, I'm into it. I'm into it. At the end, Galoom, this chat's been copyrighted by Nintendo. Hey, you can get away with it now. Nintendo won't copyright you for it. How friendly are when you think you're nice? I really don't think I'm that nice, to be honest. If I'm being honest, I don't think I'm that nice. I think I'm a jerk. Whatever. Atlas lets some channels post the last palace, but yeah, because I'm a little self-centered. No, I'm pretty self-centered. I've learned this year. Independent tort, like intentional infliction of mental suffering. Instead of an employee could establish a link between stress-related symptoms to the manner in which he was dismissed, an extension of the notice period was available. Like, why would I be doing this? Like, it's really a joke move. Extensions of the 2 to 9 month range were common for bad faith conduct, where dismissals were made in humiliating, malicious, disrespectful, callous, or undignified manner. The game died again. Oh, try, what are you trying to play on, computer? Atlas lets some channels post the last palace, but yeah. Oh, that's sick. You're not mean, can't confident or friendly. Well, I mean, it means a lot. I don't know. I gotta change how I think about myself, you know? Persona gets announced for Switch, I'm 100% that. Oh, absolutely. I gotta change how I think about myself and stuff like that. Which is why, like, face cam hasn't really happened either. I'm getting closer to it. I'm leaning up to it, but it's still far away. My Xbox? Oh, okay. It might not be optimized. Maybe there's an update for it, and you could try again. Alright, but now, see, the decision in the Keys case developed CFS and was terminated after refusing to see a physician selected by the employer. The trial judge found the employer had committed acts of discrimination, harassment, and misconduct against Keys. Yeah, he did. He did. Like, if I said, I said, Resident, you have to go see Dr. Xavier, alright? You cannot go... No, wait, never mind. What's his name again? Trevor? Oh, God. Oh, I don't have his name anymore. What did we call him? Kevin? Caleb? Darn it, I'm an idiot. I know it's a C. Carter, thank you. I can't believe I forgot Carter's name. Alright. If I tell you, you have to go see... Resident, you have to go see Carter to see if you're healthy, okay? You have to. No choice about it. He's gonna give me the health thing. That's alright. Carter's also a doctor. It's okay. But you say, no, I want to go to my family one instead. And then I fire you? I'm gonna get so hurt for that. Oh boy. You're allowed to go to the physician of your choice, because it seems like now with that I'm saying, like, he's the only one, Carter's the only one, Mr. Mango, Carter's the only one that can do it, because he's going to be in favor of a lot of things maybe that shouldn't be allowed or something, you know? So, I'm going to get hurt for that. So I'm discriminating by saying your other one's bad. I'm harassing you by saying you have to do this or you're fired. I'm harassing you in that way. And it's misconduct, because it means I'm stopping you from being able to do work properly and ethically. Yeah. Alright, he increased the notice period up to 24 months of award additional damages dependent on the manner of dismissal. That is the Wallace damages right there. He also awarded punitive damages against the employer in the amount of $500,000. So, I'd have to pay you for 24 months of work that you're not doing, and and Wallace damages, and I'd also be hit for $500,000. Holy crap. On appeal, the punitive damages are reduced to $100,000 by the Ontario court. Alright, so if I appealed it, then I get $100,000. Oh my god. Right. Because my mom said it was my turn on it. Oh, I'm sorry it's not working though. That sucks. Maybe there's a different game? Free, that spells F-R-E-E, that spells freecredit.com, baby. Oh, do you guys remember the freecreditreport.com commercials? Those were great growing up. But the SEC set aside both the award for aggravated damages and punitive damages. You got 500 grand, dude. He's just wrongfully dismissed. That's why it's also important to know this stuff. Like, this stuff applies to your guys' work stuff too. Even if this is Canadian, some of them are going to be pretty similar to like the States, might be similar to the UK, might be similar in some other ways, you know? Keys was wrongfully dismissed. The award of damages reflecting the need for 15 months notice was maintained. The SEC declared that in determining what constitutes reasonable notice for termination, courts should consider the character of the lost employment, the employee's length of service, their age, the employee, and the availability of similar employment, having regard for the experience, training, and qualifications of the employee. Yeah, $500,000 you said. In the employment law context, damages resulting from the manner of dismissal will be available if they result from circumstances described in Wallace, namely, where the employer engages in conduct during the course of dismissal that is unfair or is in bad faith for being, for example, untruthful, misleading, unduly sensitive. But rather than extend notice, basically what that means is it got extended from that 12 months to 24 months, right? But then it got dropped down to 15 on appeal. Basically what this means is when Resident decided that he wanted to go to his own, he was put on notice, right? Even though it was wrong notice, it was still, even though it was unjust notice of dismissal, it was still notice. And during that time, I might have been like, you know what? No, you're out of here. You're out. You don't even come to work. I will pay you for this, but don't even come to work, alright? Because you didn't go to that doctor, and I was being a jerk to you. Thus, that's why that was extended from 12 months to 24 down to 15. That's why I have to pay you that extra time. On top of punitive damages, on top of, what is it? No, it is punitive. It is punitive. Yeah. Holy crap. Valentine's mango pun. I think you're appealing. Carter's flattered. Who knows how to do this? Lawyers do. Oh, we're talking about that? I have no idea how to do that. I can copy paste it though. But rather than extend notice, these damages should be awarded through an award that reflects actual damages. As to aggravated damages, these are reserved for cases where the employer displayed egregious bad faith in the manner of dismissal. So if during the time you were being dismissed, I was just like, whatever, you're out, man. I don't even care about you anymore. I know you got a kid, but who cares? Kid cries all day. Like, come on. I'm gonna get in trouble for that. Egregious equals conspicuously bad or offensive extreme. Sorry. Punitive damages are restrictive to advertent wrongful acts that are so malicious and outrageous that they are deserving of punishment on their own. Wrongful dismissal procedures. $50,000 or less. Provincial court, civil, small claims court. Yes, that was raised from $25,000 in 2015, 2018? I think it's 2015. 2015, it used to be $25,000 or less. Now it's $50,000 or less. Over $50,000, Alberta's Court of Queen's Bench statement of claim, statement of defense. Settlement is encouraged through special cost awards. Parties can file an offer to settle to make a payment to court if the matter still goes to the trial, and the result is no better than the offer in the trial. The parties will not trust. To sue or not to sue. Chad, a 24-year-old junior purchasing agent, was terminated due to downsizing of the department. He worked there for 2 years, 11 months, and was given 2 weeks' notice of termination. What should Chad do? Commence a civil action in provincial court claiming wrongful dismissal, file a complaint with employment status claiming termination pay, Chad should not sue, focus on finding a new job, commence a wrongful action in the court of Queen's Bench. Because he worked there 2 years, 11 months, not 3 years, 2 weeks' notice is in fact rights, he should not sue and should focus on finding a new job. Beth, a 48-year-old administrative assistant, worked for this employer for 18 years, a monthly salary of $3,000. Dismissed due to personality clash with new manager, offered separation package equal to 6 months' wages, plus benefits, and asked to sign a full release. So the problem is that 6 months should actually be 18 months, but because it's a lump sum, I guess that's why. She should, you gotta go 18 times 3,000. So if we go to 18 times 3,000, that's $54,000. That's over $50,000. You should file a civil action in provincial court claiming wrongful dismissal. Yes. No. Queen's Bench. Queen's Bench. Queen's Bench is over $50,000 that we just learned, and provincial court, which is small court, is $50,000 or less. It's $54,000, so thus it's D. Bam. Let's call Chad. Sad. It finally worked. Yay! Alright, that game is a little messed up then. Jacob, a 26-year-old mechanic in small auto body shop, was dismissed for cause after 6 years employment for a single incident of being intoxicated at work. While intoxicated, put wrong brake pads on, but unfortunately, mistake was caught before the car left. Jacob was extremely apologetic about incident and otherwise had good work record. What is Jacob's best advice to do? I would say D. Disproportionate. You can't fire him for that necessarily because there was no actual harm. It has to be progressive. He should just have the written warning at most. Meredith, a 38-year-old senior broker who was lured away from another brokerage firm 2 months ago. Due to plummeting stock market, Meredith is dismissed. Meredith is 4 months pregnant. The employer offers a separation package equal to 2 months' pay. Well, you should also file a complaint asking for I would say C. I'd go B. B. File a complaint with employment standards claiming termination pay. Yeah. Because they have to be able to sue for the time. Because she's 4 months pregnant, she's going to have a harder time finding a job, so it's going to be a long time. And if it happens to go into like 5, 6 months, there's no way she's gonna get a job. No one's gonna hire a pregnant lady because she's gonna immediately go on leave as soon as she starts her job. Or 3 months as soon as she starts settling down. No one's gonna do it. Go to provincial court claiming wrong dismissal. Done. You know where it's from? Can you show a name? Oh, apologies. This is New Super Mario Bros. Castle theme revamped. Apologies, dude. Sorry about that. I got so into it. I got so into it. That's fun, man. This is fun to figure out. I love it. Feel so smart. Do your homework. Alright. Avoiding wrongful dismissal claims. Do your homework when you're hiring. Do you want the link to it, dude? It's also in the playlist, but... Here you go. In case you want it, dude. I knew that song was familiar. It is indeed. Thorough reference checks and comprehensive interviews. Make effective use of probation periods. If it's longer than 3 months, be sure to provide for ESC notice within the contract. Create a paper trail. Document... You're fine? Okay, cool. Well, it's there anyway. Create a paper trail. Document. Put a termination clause in the contract. It must exceed ESC, but not equal reasonable notice. You should provide reasonable notice of changes and determine if just cause claim is sustainable. Do a full investigation and consult a lawyer who specializes in employment law. If no cause or insufficient cause, determine an appropriate notice period. Okay, it is different. Handle termination interview professionally. Respect the right to privacy. Be sensitive to personal circumstances. Be brief, clear, and honest. Have a witness make no unsubstantiated allegations. Pay all outstanding wages and vacation pay. And if severance package is offered, give the employee time to review with counsel. Oh yeah, this is the castle theme from New Super Mario Bros. Wii. Avoiding wrongful. Alright. Notice of a termination must be in writing and should be clearly indicate date termination is effective. Indicate general reason for dismissal. Do not make allegations you cannot prove. Explain severance package, if any. Provide employee with name of contact person in case she has further questions. Too awesome not to remember. Indeed. Avoiding wrongful dismissal claims. Treat employee with dignity. If possible, give someone some input into the manner her dismissal is announced to others, while retaining control over the situation. Provide outplacement counseling. Provide letter of reference. Get signed release, but later provide reasonable opportunity to secure independent legal advice. Record of employment must be issued within 5 calendar days. Separation packages, an employer must deduct and account for the employment insurance for any amount of pay in lieu of notice the employee received during a period when the employee also received EI benefits. That wallpaper when your mom sees an F on your report card. Yeah. Yes. I love it. In case you're wondering what he's talking about. There it is. Okay, which is not one of the factors, right? Their size. The length of service, their position, their age, and who they are does constitute, yes. They apply proportionality, but they do not apply near cause. Alright, we done here. Alright, post-employment obligations. Common law obligations. It is an implied term that an employee serve an employee honestly and loyally. The aspects of these duties continue even after the relationship terminates. Boink wrong. Love me some new soup. Kind of get. Aspects of these duties continue even after the relationship terminates. The duty not to disclose confidential information, client lists, or trade secrets is one of those duties. This applies equally to managers and those in non-managerial positions. You. Schwanky. That's the kind I got. That is a nice soup right there. I was gonna go play new Mario Bros. Wii, but then I remember my Wii is at my dad's. Oh, Hopefully soon, dude. Hopefully soon. I got something to look forward to. I want to play it now, too. Okay. The duty not to solicit or compete with a former employer does not exist, unless there is a restrictive covenant that provides otherwise. However, those in a position of trust may owe the former employer... Employment starting code. Yes. Okay, sorry. Those in a position of trust may owe the former employer fiduciary duties, even absent... I love this song. Sorry. I love it. However, those in a position of trust... Ooh, I love my apple juice. Those in a position of trust may owe the former employer fiduciary duties. Even absent a restrictive covenant, they cannot solicit former clients if they developed that relationship while employed by the former employer. As a fiduciary, one is bound to put the interests of the other party first, ahead of personal interests. I need this song. I just imagine every time it comes on, I imagine a camera zooming in and out, and everyone just going wild. I love it. Even absent a restrictive covenant, they cannot solicit former clients if they develop the relationship. Alright, I'll grab it for you. There you go. Like this part right here. They cannot solicit former clients if they... No worries. If they develop that relationship while... This thing is called Miss Monomi's practice lesson. That's what it's called. I gotta make thumbnails for Dangan too, I just realized. As a fiduciary, one is bound to put the interests of the other party first, ahead of personal interests. I love the execution song of the first execution in D2. I can't wait to hear it. It should be interesting. Fiduciary employees, those in a position of trust. Senior or key employees, those who would significantly affect an employer's interests. In Canadian Aero Service LT Limited versus O'Malley, I think I remember that one. A president and VP took advantage of an employer's business opportunity, developed the relationship as employees, and then bid on the job themselves. The SEC found that as fiduciaries, they owed the employer a duty of loyalty and duty to avoid conflict of interest, both of which continued after the employment relationship ended. Gotta stay hydrated. Alright. Fiduciary duties. May survive the employment relationship. May be required to account, pay over any gains made in breach of these duties. Not to compete with former employer. As in the KJA Consultants case, former fiduciary employees of businesses that rely on personal services may not compete with the former employer for a reasonable period of time after leaving employment, even where a client of the former employer seeks them out. Restrictive covenants. Confidentiality. Protecting the employer info and secret. Employer's info and secrets. The employee must not misappropriate confidential information or trade secrets belonging to their former employer. Applies both during the term of employment and after. Information that forms part of an employee's general experience and knowledge does not constitute protected confidential info. Confidentiality. Identifying confidential information. If the circumstances are such that any reasonable man would have realized that information was being given to him in confidence, then this should suffice to impose upon him the obligation of confidence, or in particular, where the information of commercial value is given with some avowed common object in mind. Some tests of what is confidential. Information should be injurious to employer or helpful to competitors if released. Information is secret, not in the public domain. Above two beliefs must be reasonable. Must be judged in light of it. Yeah. Gotta go. See ya, tacos. Thanks for being there. I appreciate it. Have a good rest of your day, man. Have fun with Smash. I added bomb rush blush on my SSD Ribless. Alright, sweet. Can't wait to hear it. It's all random. That's why. Alright, examples are computer programs, lists, assessments, processes. Yeah, right. Former employees have the right to compete without constraint in the employment market, including the right to solicit the former employer's clients. You may do so by establishing a business in direct or partial competition. They may bring to that the business that knowledge and skill which required while in the former service. Non-compete, non-solicit. Exception to the rule. The employee is entitled to compete and solicit, but must not misuse confidential information or trade secrets belonging to the former employer. The employee must not compete or solicit where there exists a valid restrictive covenant barring competition or solicitation after the employment relationship ends. A key employee must owe a fiduciary duty to the employer with more exacting obligations. May not be entitled to canvass former employers and customers. Originally was very restrictive, only Originally was very restrictive, only encompassed very senior executives, those vested with the power and responsibility to guide and direct the affairs of the organization. Officers, the C-suite, CEO, CFO, COO, etc., other very senior employees. Now can be applied to less senior employees so long as they play a key role in the organization. This is one of yours? Oh, I thought this was, what's the name? Asks. Weird ending. Oh, you. Oh, you. Obligations do not exist forever. The time frame of restraint relates to reasonable notice period. Additional responsibilities. Cannot quit and take advantage of a business opportunity that they discover while employed, unless they first disclose the opportunity to the employer and give them an opportunity to exploit it. Oh yeah, it's somewhere. Must disclose any info that might reasonably impact on the business of the employer. Plans to quit, starting business, etc. Cannot compete or solicit away customers for a reasonable notice after employment ends. The Employment Standard Code. Okay, let's play 3 rounds of Scriblio, if you guys want. For a brief break before we finish off the last one. If anyone wants to. You do not have to. I want to say that. You don't have to play if you don't want to. Alright. The break does help, though. Just saying. See you, Miles. Got Junior. Nice. Resident Pew, you guys want to play? Shy Guy, if you're still here, I guess. I love this version of the song, I will say that. You want it now? Alright, sweet. Alright, let's jump in. Anyone can join anytime. The 3's a lot easier to start with. Oh! No, not a tree. No way! Sweet. It's, it connects to the tree. Like, okay. Worth a shot. Tie. Oh. Huh. I have a feeling the first word's man. Man. Oh, boy boat? Mr. Bean! Oh, I'm a dummy! How could I not? I'm sorry. When you pick emoji, you probably shouldn't have. Oh, I'm sorry. Is it getting that bad? Y'all ready for this? It's easy. Using a string on there. There we go. Easy! No story. Everything else taken, at least what I'm good with. Oh, that's okay. I bet you'll still rock it. I see what you mean now, I'm sorry. I'm dumb and not thinking stuff fully through. At least you get to play as your girl. That's such straight lineage, holy crap. It's a door. Oh no, it's not a door. There's a capital in it? Is the last word bar? 1, 2, 3, 4, 6. Oh! No, it's not a chocolate bar. SpongeBob! Oh, I see it. Sorry. It totally does like a chocolate bar. That was on its own. Devil. Doubt it. Anger. What do you eat food with? What do you talk out of? Okay. hope this is gonna be easy. Alright. That doesn't look very good, does it? On this end, there's like... There's a blaster. And it has like... fire coming out, like... And... Okay, good. I was about to draw space. Oh, I thought you died. I did for a second. My internet went out. How you doing, Nap? We're just taking a break, finishing off our couple rounds of Scribblio before we finish off. Alright. Alright. What do we got here? Corey of the House! I love his remix. How you doing, Nap? Welcome back. Oh, I'm gonna feel so stupid. You know, I think we've had this one before. Oh. Oh, okay. All right. When two people are at a wedding, they're what? They're in... You could say that they're in... There we go. I know, Corey kind of slapped though. We'll do 3 more after this, and we'll call this game done. Oh. No! No! Misspelled it. Alright. Of course I'm gonna choose this one. Y'all better get this in like 3 seconds. Alright, I thought that would be enough. The guy often wears that kind of hat. He has blonde hair. It looks like Elf. Oh my god. How to spell. Alright, we'll do 3 more and then that's it. We gotta finish the last PowerPoint. Here we go. Napwhack is up. Watch out, little baby. No, it is not. You got mustard on him. Stupid blue, that's Link, not Zelda. Oh, you're right. How could I possibly... Darn it. Peach. Oh, no, it's not Crown. Oh! Oh! Little Mermaid is one of these. Snow White. Cinderella. Moana. Jasmine. They're Disney blank. Zelda is one of these. Oh, just one letter. It's okay, it's okay, you're okay. You're close, Snap. It goes on it. I personally like soft versions of this because the hard ones, like, I found them to be too messy. I don't know how people can eat that. There we go. What's the rule in the Incredibles when she's making outfits for people? Never mind, this is working fine. Beautifully. Awesome. Awesome. See, it's because you're good at it. It's because you're good with her. You shouldn't wear blank in Incredibles because it often leads to death. Don't worry, this one's easy. In Mario, these things often have there we go. Bullet! Too easy. It is. So I chose it. Easy points. Something to get through quick. Oh, amazing. Nintendo makes it easy. Oh yeah, absolutely. It's a turtle. Mark Simpson. What's a glove? It's a boxing thing. Also cuddly emojis and voice lines. Are they good? They're that good, eh? Oh, so... Oh my god. Oh, it wasn't a boxing glove. Are too adorable. Oh wait, you did get her, eh? Oh. It's okay, you're okay, Nat. No, I didn't, but someone used skin booster. Oh, okay, alright. Cool then. a tough one. No! Darn it! Oh, darn it. I see it though. I see it. Skin booster basically means we can use any non-limited edition skin for one game. Oh, okay. I figured it was something close to that. That's awesome. Oh no, that's that Sydney Hall. Is that Sydney, the Disney Hall? Oh crap. It's a Sydney. No, that's not what it's called. I thought it was a... Phew, good job. Oh, I said Oprah before. Oh god. Oh god, I can't remember how to spell opera. E-R-A. I thought there was an H in there. Oh, I'm stupid. Actually, we'll make it bigger. And at nighttime, so during the day you can't really see it, but at nighttime, when it gets dark, suddenly it goes like, but only after you take the thing there and you bend it so you get a... No, it's supposed to be an R-A-C. There. And it goes... And then suddenly it does that. It also comes in different things. It goes... And it goes... It also comes in different colors. Okay. Yeah, I'll stick. Sorry. Might be is that color? That's a word? Indeed it is. Glow stick. What's the last round? We gotta read the last PowerPoint. That was easy. I am Picasso, indeed. No, hoses. No. There we go. We're getting easy ones. Oh no. Oh. No. School. President. Principal. I tried something else. Oh, it's a graduation hat. I thought I'm sorry. That makes sense. Okay. Oh, who left? No, Pew. Aww. It's okay, dude. It's okay. It's okay. Oh, Nap, you stole it. Oh, no. You sneaky. You're sneaky. Alright, I gotta get back to studying. You always do this. Oh my god. You gotta go? Yeah, no worries, dude. No worries. Thank you so much for being here. I appreciate it. We're gonna learn about privacy before I call it quits. Oh god. There are so many. Actually, I know this stuff. This one's not hard. It's what, like FOIP? PIPA? If you're not playing, I'll stick around. Oh yeah, I'm not playing anymore. Sorry. Otherwise, I want to play alt. Yeah, no worries. I gotta go say goodbyes. Oh, see ya, man. Thanks for being here. Have a great sleep tonight, okay? Thank you for joining me and helping me study. I appreciate it. Alright, this one's gonna be we're gonna go through this one quickly, alright? The privacy of personal information is a relatively new info. In the past, privacy was protected by practical difficulties in compiling records. Nowadays, there's a lot more sensitive things. The Privacy Act took place on July 1st, 1983, applies to the information that was collected by employers, but now that's no longer the case. Employers, doesn't matter. It's any information that's deemed sensitive between the employer and the people given the information themselves. It has to be in writing, and it cannot be just given out willy-nilly. If someone asks for a reference, it's not okay to ask and give them that information, you know? The Privacy Act gives individuals the right to access and request correction of personal information about themselves held by these federal government organizations. So anytime right now, I can request that the government give me all the information that they have on me that was given by my schools, by any people I've worked with, anything and such. The privacy law governing the private sector increases use of
Check out my new song Di Mi Nombre from my album El Mal Querer in the new YouTube Music app.
The increases use of electronic means to compile and transfer personal information led to the development of further privacy legislation to regulate how personal information is handled in the private sector. The PIPEDA, the Personal Information Protection and Electronic Documents Act, governs federally regulated organizations and how they may collect, use, and disclose personal information. So that's PIPEDA. FOIP is also federal, actually, I believe. We'll see it in a sec. Personal information includes things such as age, sex, religion, ethnicity, opinions, photographs, ID numbers, home address, residential phone number, personal email, web browsing, purchasing, spending habits, income, credit records, loan records, disciplinary actions, employee files, pay, benefit records, blood type, medical records. PIPEDA sets out the ground rules for how private sector organizations may collect, use, or disclose personal information in the course of commercial activities, but it doesn't apply to anything that is provincially regulated. Federal government enacted PIPEDA to cover the personal sector held by organizations in the private sector. It applies to personal information collected, used. What was the word? My phone died? Oh, the last one? Snail. Yeah, it was snail. No worries, no worries. I was worried you got mad. Oh, bye. Oh, see ya, Pew. Thank you so much for helping me study today. I appreciate it, and thank you for playing. You're awesome, dude. January 1st, 2001, federal government enacted PIPEDA to cover the personal information held by organizations in the private sector. It applies to personal information collected, used, disclosed, and retained on employees and customers in federally regulated industries. But on January 1st of 2004, it also applied to the personal information collected, used, or disclosed in provincially regulated industries, and of course, commercial activities. Yes. PIPEDA, who's covered? In Alberta and BC, other provinces passed comparable legislation. The Personal Information Protection Act, PIPA, for provincially regulated industries. In November of 2013, the Supreme Court of Canada struck down Alberta's PIPA, providing the government 1 year to bring the act into compliance with the Charter. Yeah, it went against the Charter of Rights and Freedoms because they believed that it violated the freedom of association. Alberta's PIPA was thus amended by the Personal Information Protection Amendment Act to allow a trade union to collect, use, and disclose personal information without consent. That's why it went against. On June 18, 2015, some Federal Digital Privacy Act was proclaimed, with some key changes to PIPEDA. No, I'm saying bye to Fug. Oh, okay, I thought you were leaving suddenly. Alright, cool. Still, thank you for being here. Where security has been breached and there's a risk of significant harm, the organization must report and keep records of the breach. The definition of personal information has been broadened. PIPEDA now covers applicants as well as employees. That's awesome. That means if I apply for a job and they have the information on me, the information that I gave them is protected. They can't just do anything they want with it. Business, whereas before June 18, 2015, they could have sent it out to somebody. Business contact information is exempt if used solely for the purpose of communicating for business, employment, and professional matters. Permission to disclose without consent to third parties has been broadened in cases involving illegality, fraud, and financial abuse. The Privacy Commissioner can enter into compliance agreements. Nixter, how are you doing? Great to see you. Hope you're having a great day. You deserve it. Thanks for coming. I appreciate it. How you doing? PIPEDA's 10 Principles. Oh, I love this song. I love it. Employers need to respect the 10 principles set out in Schedule 1 of the Act, as modified or clarified in the Act itself. Accountability. The employer is responsible for the personal information under its control and must designate someone who is accountable for its compliance with the Act. So, they're responsible while they have it, and then they have to hand it off to somebody within the position to make sure that it's protected within the government, that it's turned in properly, you know? See the song I added? Can you? Oh yeah, look at those. Thank you for watching out for that. Sweet. My win rate with Moji is ranked at 20-5. I should totally be on the Moji leaderboards by now, but I'm not. Really? I don't know why. I don't know why it surprised me. You'll make it on there. If anyone can, it's you, dude. Identifying purposes. They must have a reason to why they were collecting that information to you in the first place. At or before the time. Consent. So if they're going to do it, they need my consent. They need to say, like, can we collect this? Oh, yeah, sure, man. Sure, you can collect it. Awesome. So that means if I'm going to hire one of you guys, if I'm going in, if I'm interviewing Professor Shy Guy for a job at my firm here, and Carter's here as well, he's the one that hands it off to the government. Then I have to ask him, hey man, I need to collect this information. Is that okay with you? And then if he says yes, awesome. If not, then I have to avoid that information as much as possible, although it won't be really good for him, because I'm going to get the information I need to hire him, you know? The limiting collection. Employers may be allowed to collect the personal information that's necessary for the purpose they identified, unless collected by fair and lawful means. By that means, I have to ask you. I don't know how the leaderboard works at this point. I'm guessing it's not based off win rate, because that would be first without a doubt. It must be some other aspect to it. There has to be. Maybe how long you play, if they use the digital pass, or the battle pass, and stuff like that. Nice. Alright. Limiting use, disclosure, and retention. Unless they have the consent of the employer or legally required to do so otherwise, the employers may use or disclose personal information only for purposes in which they collected it, and they may retain it as long as necessary for those purposes. Nothing else. If I say it's only for the interview for Professor Shy Guy to hire him, that's all I can use it for. I'm not allowed to hold on to it and use it later on. That's illegal. Accuracy. The employee's personal information must be accurate, complete, and up to date. Safeguards. The personal I'm going to print off this. I'm gonna print off this one sheet. This is gonna be important. 21. There we go. Cool, it's printing. Alright. Openness. The employer must make its personal information policies and practices known to employees. So if I'm taking information, you have to know what I'm going to do with it. That means, like, am I saving your browsing history, you know, to make sure that you guys are working, right? If I find out, like, oh, you guys are on Facebook 90% of the time, that's bad, you know? Individual access. The employees must be able to access personal information about themselves and be able to challenge the accuracy and completeness of it. Absolutely. You can if you want. It's there. Just ask for it. Challenging compliance. Employees must be able to present a challenge about the employer's compliance with the act to the person that the employer has designated as accountable. Yes. So you got to talk to Carter if it comes up. See the Eastman case. Eastman. No. Steps to compliance. Appoint a chief privacy officer, a CPO. I don't know why this reminds me of Wave Prism by Trippy Chirps. Maybe it's like, maybe it has the same build-up. It's the best Splatoon 1 song, my guy. Wait, which one's this one? It's Seascape. It sounds good. Sounds really good. Splatoon 1 had the best music. Assess how organization collects, stores, retains, uses, and discloses personal information for customers, clients, patients, suppliers, and employees. Include marketing, sales, HR, payroll, finance, purchasing, technical. Develop policies and procedures to bring organization in compliance with PIPEDA. You have to train all the staff to ensure awareness, monitor compliance to policy, document and publish privacy policies, and train employees on privacy rights and obligations. Provides freedom of FOIP provides individuals with the right to request access to information in custody or control of public bodies. So my school, my old high school, and even my current school, you have to sign a FOIP form, and in return they can take pictures of you to put in the yearbooks. You know, they can have the cameras watching at all times and stuff like that. You know, yeah, put you on the websites, stuff like that. Public bodies include a department, branch, or office of the government, an agency, board, commission, corporation, office, or other body designated as a public body in the regulations of the Act. Educational bodies, healthcare bodies, local government bodies, self-governing professions. Freedom of FOIP provides access to records unless the Act specifically allows for the record to be withheld. The right for access is balanced by the need to protect individual privacy. Alright? You can ask to see records held by government. You have the right to request that your personal information held will be corrected. Individuals can also complain to the Commissioner if they believe their personal information has been collected, used, or disclosed in violation of the Act. What's the difference if I'm on Facebook 90% of the time, as long as the work is done on time and in good taste? There we go. Yeah, you know what? That's a good point. So then I'd have no reason to check you. I have no reason to check you. But if work is like constantly like... You're right, I didn't specify. That'd be bad. That'd be bad. But like if Q here wasn't turning in work enough, like wasn't completing the site on a timely manner or anything, he would need to... I could check to see like what on earth is he doing. Get ready for my song coming up. Oh, it's random. We have hopefully it'll be up next. It probably will be. Underlying philosophy of the Act. Oh, the purpose is to make the governments and public agencies more accountable by giving the public a right of access to their records. Thank you for that, Godamon. That's going to come in handy for the test. The underlying philosophy of the Act is that citizens will have their private information protected if those collecting it are compelled to be transparent, fair, and credible. PIPA. In 2003, BC enacted a legislation comparable to PIPEDA called PIPA for provincially regulated industries. It includes workplace rules for employee personal information. So, whereas PIPEDA only goes towards federally, provincially regulated private businesses, PIPA goes towards the provincially regulated ones. So things like stores, like Walmart and Safeway, whereas before, where PIPEDA goes towards things like, let's say, oil refineries, you know? In 2004, Alberta enacted legislation comparable to PIPEDA, called PIPA, for provincially regulated industries. It includes workplace rules for personal employee information, amended 2005, 2009, 2010, 2014, and comprehensive review, and were presented to the government by December 2016. Holy crap. Alright, provincially regulated organizations to which PIPA applies include non-profit organizations, trade unions, private schools, partnerships, corporations, unincorporated associations, professional regulatory associations, any individual acting in commercial capacity, any individual acting on behalf of a corporation, unincorporated association, trade union, or partnership. Principles. It governs the collection, use, and disclosure of personal information by private sector organizations. Recognizes both the right of an individual to have his or her personal information protected and the need for organizations to collect, use, or disclose personal information for reasonable purposes. Personal information in the custody or control of private sector organizations as it relates to commercial transactions or activities are subject to PIPA. For workplace, PIPA also covers personal information about employees. PIPA allows individuals to request access to their own personal information, including employee information, and to request correction. Individuals may also we have reread that. Okay. Steps to compliance. You must appoint a CPO, assess how the organization... We did that already. Yeah, you appoint him. You need to say how you use it and where it's stored. You have to make sure you're up to date with the acts. And then you have to ensure that everybody knows it. Yeah. Oh, I forgot about monitor performance. Alright. What is personal information? Includes such things as age, ID, we read all that already. PIPEDA case. Can't read it. PIPA defines personal employee information as in respect of an individual who is potential current or former employee of an organization, personal information reasonably required by the organization for the purposes of establishing, managing, or terminating an employment relationship or volunteer work relationship, or managing a post-employment or post-volunteer work relationship between the organization and the individual. Oh man. Alright. But does not include personal information about the individual that is unrelated to the relationship. Smash Ultimate's almost done updating. So what? Yeah, Mix, how you doing, man? I hope you're having a great day. You deserve it. Thanks for coming. I appreciate it. Wait, did I say hello to you already? I think I might have. No, I did not. Alright, how's it going, man? How's school? I'm jealous. Governs an employee's right to protection of privacy when under video surveillance at work or when an employer monitors email or other electronic communications. Employers can get written consent of the employee to collect, use, or disclose employee personal information, but in the absence of such consent, an employer may nevertheless conduct these activities if the actions are reasonable for the purposes of establishing, managing, or terminating an employment relationship. Did you see the new person Yamix yesterday? I thought that was pretty sweet. I checked my friend's Best Champions leadership boards. He's in Masters. He has a solid win rate for all his mains, but he's not in any leaderboards. Huh. Yeah, something's up. You should see how they analyze it. Just got here. School is super long since all the game was Smash, and my brother was 48 minutes getting out. Ah, I see. I know this song is 10 minutes, but sheesh. Is it? Oh yeah, that is a long time. Sorry, I didn't see that. What about... Oh, the DLC yesterday? The DLC character? That was pretty cool. Collection of personal employee information.
McChicken on the beat.
Oh my god, no.
You girl, wash your feet.
I just couldn't do it right now. Information is disclosed solely for the purposes of establishing, managing, or terminating. That is right. I am so sorry. I'm so tired. I'm sorry. Have fun with Smash, dude. I'm an idiot. I'm so sorry. Oh my god. I can't believe that. Boy, Wastelands is a giant. I'm sorry. I clicked the other one to just give it a... I'm sorry. I'll go back. Managing a terminating employment. Okay, termination, managing a temp. Managing a post-employment or post-volunteer work relationship between the organization and the individual. It is reasonable to disclose the information for a particular purpose for which is being disclosed, and in the case of an individual who is currently employee of the organization has, before disclosing the information, provided the individual. Oh my god, this paragraph is so long. The personal employee information of the individual is going to be disclosed, the purposes of which the information is going to be disclosed. Shut up. Oh my god, that was the worst sentence I've ever read. Alright, let's see this excerpt from PIPO section 21. An organization may disclose personal information about an individual who is current or former employee of the organization to a potential or current employer of the individual without the consent of the individual if the personal information that is being disclosed was collected by the organization as personal employee information, and that the disclosure is reasonable for the purpose of assisting the employer to determine the individual's eligibility or suitability for a position of that employer. Oh. I'll probably just grind Moji for a bit in quick play. I'll go to level 41 on the grind. To golden Moji. Oh, you're close, dude. Holy crap. I didn't realize it was golden characters. Talk about an awesome trophy. I need to take one of my pills. Sorry. Okay. Risatsu Shores Homeowners Corporation. Can't do it. Oh, I guess I can read that. That an improper disclosure of job performance info to third parties was done without prior notification of the employee that the info would be disclosed. Also found that disclosing the info that was not related to the employment was improper. Also, the employer used inadequate measures to protect the privacy of information. Employee surveillance. If unionized, the collective agreement may have provisions restricting employers' ability to conduct surveillance. If no union. Unlike workers in BC, Albertans have no Privacy Act that creates a statutory tort of invasion of privacy, so we're left with the courts and their application of common law and Python. So where I live now, they're allowed to put cameras in, they're allowed to just always constantly monitor everything you do. Where surveillance is conducted to observe employee conduct or performance, a court or arbitrator may find video evidence admissible in wrong dismissal action. Privacy rights of employees may sometimes be infringed at work in ways such as the following: keystroke monitoring, monitoring of websites visited, monitoring of outgoing or internal emails, video surveillance of employee activity, and collecting biometric data like a voice print or fingerprint. Whoa. Depending on the circumstances, drug and alcohol testing at work may infringe on both privacy and human rights. Infringement of privacy rights may occur when an employer provides reference check information to another who is called without proper authorization. Privacy is also infringed upon when an employer discloses personal information without prior notice to the employee to a third party who did not ask for it. Guidelines on covert surveillance issued by the Federal Privacy Commissioner. The Office of the Privacy Commissioner considers covert video surveillance to be... Oh, it's not on that anymore? I'll go back to Mario Strikers after this one. Like how all the non-watches left. Yeah. It's okay. That's alright, it's a homework stream, I don't expect anyone to be here. I was expecting anyone with Smash out, to be honest. I didn't want to bug you guys. I almost didn't post anything. Just would have just started up the stream with no warning. Or may lead to judgments about the subject that have nothing... Oh wait, video surveillance to be extremely privacy invasive form of technology. The very nature of the medium entails the collection of a great deal of personal information that may be extraneous and may lead to judgments about the subject that have nothing to do with the purpose of collecting the information in the first place. So, Joker and Smash, any thoughts? Oh, it's awesome. I love it. I love it. What do you think, Ryan? And I hope you're having a great day because you deserve it. How you doing today, man? A common misconception is that organizations are released from their privacy obligations if covert video surveillance is conducted in a public place. In fact, under PIPEDA, any collection of personal information taking place in the course of a commercial activity or by an employer subject to PIPEDA, regardless of the location, must conform to the requirements described below. Purpose. There has to be a reason to why you're collecting the information, right? They have to have consent. So that's why you see a sign like before you enter a building that says, in this building we collect video surveillance. We have cameras, you know? And by entering this place you agree, blah blah blah, that is right. Really makes me want to play Persona 5. Hope I can get it for my Vita or when it comes to Switch. I bet it's gonna come to Switch next year. I really do. I gotta finish it, but yeah, I really want to play it too. Also, I'm really hyped for it. Me too. It's so cool. I had no idea it was gonna come. I was just like, what? It's awesome. Cleanse Ryan of Sony. Sony's good. PlayStation 4 is awesome. Limiting collection. So, you can't collect everything. That's why, like, for example, you'll see, when collecting personal info, organizations must take care to limit both the type and amount of information. Alright, yeah. Okay, so nothing that can show who they are, really. Yeah, we wouldn't have Danganronpa. We wouldn't have Digimon. We didn't have Bloodborne, Dark Souls, Witcher, Spider-Man, Tales of Zestiria, all kinds of wonderful games. Destiny. Sony is good. I think it's gonna come to Switch. I think so. I have a good feeling about it. There we go. Documentation. Organizations should have in place a general policy that guides them in the decision-making process and carrying out covert video surveillance in the most privacy-sensitive way possible. There should also be a documented record of every decision to undertake video surveillance as well as a record of its progress and outcome. I'm 100% Nintendo dork. You're not a dork. That's okay. Nintendo's awesome too. They're all awesome. All three of them. Organizations use covert video surveillance. Should implement a policy that sets out privacy-specific criteria that must be met before covert surveillance is undertaken. So everything we just read. I'm getting tired, man. I'm getting... Oh, boy. Alright, Nick, you can do this. Alright, documenting specific instances of video surveillance. There should be a detailed account of how the requirements of the organization's policy on video surveillance have been satisfied, including a description of alternative measures as undertaken and their result, a description of the kind of information collected in surveillance, the duration of surveillance, names of individuals who viewed the surveillance, what the surveillance was for, when and how images were disposed of, and a service agreeable with any third party hired to conduct the surveillance if applicable. Oh, which one is not one of the 10 fair information? D. Yeah. Yeah, right, D. FOIP. belongs to employees solely cost. Held by all employers. That's pretty much it. The last one is just a final review. We did it, guys. Can you tell me like how many multiple choice questions and stuff there is? It's probably the same. It's probably the same. Holy crap. I thought she, Holy crap. That's it. That is all the PowerPoints for my last final. Oh boy, oh boy. That was a long course. No, to be honest, it's kind of in the background of everything. Oh my god. So I'm gonna be leaving in about 20 minutes to go write my exam. So I gotta go get my papers, my ID and stuff all together. Thank y'all for, I'm gonna end it here. I know there's no secret game, sorry. But hey, last one, we did it. No more essays. And I should be, tonight I do that, and then next week I should know if I graduated. Hopefully they don't take it away, which is good. So we got a graduation stream gonna come up soon. I don't know what we're playing, but we'll play something. Yeah. Alright, I love you guys. Thank you for hanging out with me today. Seriously, I left Bakugo up there the whole time? Nick. I'm dumb. Alright. I love you guys. Thank you. Wish me luck. I'll see you guys. Thank you for hanging out today, Pew. It's really cool. Really cool. Alright. Bye, guys. Really got here now. I'm sorry, Brody. We just finished. Now I gotta go get ready to go to write the exam now. Yeah, I'm really sorry. But hey, you got in at the end. Your message is in there. You're in the video. Alright. I hope you have a great rest of your day, man. I hope if anyone that has Smash, I hope you keep loving it, keep playing it, because that game looks awesome. And I can't wait to play it one day soon, hopefully. Yeah. Okay. Yeah, see you guys.